Welcome and top of the morning to you for another show of Civil Discourse Now. I'm your host, Mark Small, and also host Paul Ogden.
Good morning, Mark.
Good morning there, Paul.
I'm sorry I didn't wear green today. I came from a meeting. I didn't have a green jacket.
This is St. Patrick's Day, March 17, 2012. We are shooting this show in Broad Ripple, which is on the north side of Indianapolis. We are going to discuss today as a topic whether public intoxication should be a criminal offense. And before we get there, I just want to point out we were trying to shoot in a bar, but bar owners were hesitant to do so because they were concerned that the nature of the subject matter would reflect on them, and they have liquor licenses to worry about with the state. So I completely understand why they would not want to impair themselves in any way like that. This is Civil Discourse Now. Paul, you want to describe the show?
Well, Civil Discourse Now is a show where we talk about local, state, national, and international politics, where we try to bring a civil discussion to issues. We have too many shows out there where people are talking over each other and yelling at each other. We try to have an intellectual or somewhat intellectual discussion of the issues.
Yeah, I try to do the intellectual. Paul does the somewhat intellectual, but we're
pseudo.
And Paul, do you want to do?
Well, I want to do my disclaimer. I am a Republican candidate for judge in the May primary. Under the rules, which I have reviewed, the ethical rules for judicial candidates, which are actually different than for judges. They actually encourage you to take positions on issues, but you can't take pledges. You can't promise to vote certain ways. I can't say, well, if a public intoxication law comes before, or a case comes before me, I'm going to rule a certain way. I can't do that. So, but it does encourage people, actually candidates, to take positions on issues and get out there in the community and talk.
Our guests today, to my right, is John Tompkins, local criminal defense attorney. He's one of 5 attorneys in the state of Indiana to go through the National
College of Drunk Driving Defense.
And that's a really extensive course that they put you through on that.
Yes, it is.
And he's at btlm.com and on Twitter at John Tompkins. Our other guest is Joh Padgett. Joh? Joe's a local...
Joe didn't wear green either. So.
He did not wear green.
Well, I do have red hair, though.
Oh, well, that's yeah. But your eyes, I can't see it in your eyes, me laddie. Joe's a local activist in general, but in several areas. He's on Facebook. He's a former DJ, bouncer, and bartender, and he's a retired drunk. So we're gonna talk today about whether public intoxication should be a criminal defense. Gentlemen, who wants to go first?
I'll give it a shot.
Go for it.
Well, it's traditionally been categorized, at least in Indiana, as a criminal offense, and it's unclear why. There have been some attempts to improve the bill, improvement being a subjective interpretation, but Senator Young, who is responsible for the changes in the most recent changes in our law, thinks it's an improvement. And what they did to improve it was to say not only do you have to appear intoxicated, but you also have to be a threat to your own life or someone else's life, damaging property or threatening to damage property. And quite honestly, what they've done is just created a redundant crime. All of those things are already crimes, whether they're associated with intoxication or not. And I think that all of those things being crimes in and of themselves is perfectly justifiable.
Oh, yes.
I think linking them to intoxication in a public place as a criminal offense is therefore unnecessary.
It simply adds an element to the offense that the state has to prove, but also allows public intoxication to be a pretext for a law enforcement officer to make an arrest, to take someone into custody.
But I want to back up a little bit. We talked about the changes to the law, but John, you're a criminal defense attorney. I always want to say criminal attorney, but then that would be a different implication. But what is the state of the law and how it's enforced? If I go to a tavern here in Broad Ripple, have a couple beers, and walk out, can I be arrested for public intoxication?
You absolutely can be. The only definition of intoxication that appears in a statute in Indiana is in the traffic code and applies to operating while intoxicated cases. There is no definition of intoxication that you can say the state has to meet in the context of a public intoxication charge.
Do they have to give me a breathalyzer?
No, they are not required to do any chemical tests, certified or uncertified, or any field tests.
Okay.
Now, there is a part of the administrative code for DOC that specifies that intoxication is 0.10 BAC.
And that's you're correct. And
I wasn't trying to one-up on
no,
Jeopardy
no.
or trivia on drunk.
No, the disconnection with that is other laws already on the books in Indiana say that you can't use a test of O2 or less because of the limits of the machine and the unreliability of results that low. So,
and we had a Supreme Court decision, I believe it was last year, come down that where a person was a passenger in the car had a designated driver. So that person, the passenger, was arrested and convicted of public intoxication, correct?
right.
That was Moore versus State, I think.
Right. And it was upheld by the Supreme Court.
It was first
By our
reversed.
wonderful Supreme Court. But go ahead.
Sorry. It was first reversed by the Court of Appeals, and then saying that is not a valid conviction for the offense. And then that decision by the Court of Appeals was reversed and the conviction was reinstated by the Supreme Court. And it is an example of the current state of the use of this offense. Police officers are not out there looking for intoxicated people. They're tacking public intoxication on either to other counts. In other words, you'll be arrested for an operating while intoxicated, and then they'll tack on a public intoxication count. Or they see somebody who's behaving in a disorderly manner, and they're approaching him for a completely different reason, which gets back to, do we really need this as a separate freestanding criminal offense at state level? Or is there maybe home rule policy that would be more effective? You know, communities that have this problem could enact an ordinance and say, we want our police to be able to take these people into custody for their own safety or for the community's well-being in the caretaker function that police perform. But it's a local problem, so we're going to pass a local ordinance. And at the state level, if the people are committing these other crimes, don't lump it into an intoxication. It's another crime.
I can't help but wonder, though, if this isn't some sort of a outreach to the drunk community, though. I mean, seriously, it seems like the new standard is, well, if you're just drunk, you're fine. But, you know, if you're drunk and, you know, saying, hey, buddy, and, you know, being crazy, then we're going to come get you. But, I mean, you know, what does that say? What is that telling us?
Well, it's important to understand that the change in the law is not going to change police behavior. Okay, the change in the law is going to impact what happens in courtrooms after people have been arrested. So what the new law means is, if you're just drunk and you get arrested for public intoxication, you're going to have a great defense. It's not
By
gonna...
saying I wasn't, you know, in somebody's face or something, I was just sitting there quietly on the park bench, officer.
That you weren't endangering somebody's life, your own life or safety.
I'm all for this, then.
You weren't disturbing the peace.
Disturbing the peace is kind of very general.
But the problem with that is this. It remains a criminal offense. The significant difference for the person on the street who comes out of a bar between a criminal defense and an ordinance infraction is, you get taken down, processed, fingerprinted, photographed, you now have a criminal file. This is part of an ongoing criminalization of behavior that is expanding and expanding and expanding. So if you treat it like an ordinance, which has home rule, so local communities can decide and local voters can tell their local councils if they think it's necessary, you get a ticket for that. You're held accountable. You may be fined. But you don't get fingerprinted and photographed like someone who is committing. You're not criminalizing that behavior and creating the criminal history and criminal record.
As we pointed out, you can't have a criminal offense by a local ordinance. This be a state statute.
Correct.
So.
Now, Joe, when you were a bouncer and a bartender, and you would have boisterous patrons in the establishments in which you worked, was your recourse to call the police, or was your recourse to deal with the problem first and most effectively there in the establishment?
Well, when I was working as a bouncer, the general rules for getting rid of trouble were to try and you can't physically contact these people unless they are being physically abusive to someone else, and then we would be allowed to restrain them and then take them outside for police presence. You know, if we felt that it rose to a level of an assault or something like that, then we would hold them for the police. And I even in a couple of cases swore out citizens arrest affidavits because of someone that I citizen arrested for assault.
There's an oral statute for that in North Carolina. As Gomer Pyle famously said, "Citizens riots,
yeah.
Citizens riots." Bernard P. Fife was the arrestee in that particular instance.
Yes.
But the training that they give most people around here that work security for the bars is to try and take care of it, inside. And if the patron is being just out of line, then they have to go. As private property, the bar owner can decide who gets to stay and who has to go.
Well, I lived in Chicago, and the establishment to which I sometimes frequented had a problem with a patron one night, and they called the Chicago police. And the cops came into the bar, took care of the situation, and the cops said, "Don't call us. We're not supposed to be called for this. You call us, you're going to lose your liquor license." So it was like, you could do pretty much anything on the north side of Chicago in a bar at that time then, as long as you weren't stabbing somebody and you looked like you were employed. I mean, those were the two.
Well, I can tell you though, having worked security for several bars around here, the Alcoholic Beverage Commission does track how many police runs are made to establishments. And there's a certain level, I don't know what that magic number is, but I know that there are establishments that have been sanctioned for over-serving on multiple occasions after several police runs to the same location.
Well, Piccadilly's case in the late 80s.
Exactly.
That was allowing someone to leave the premises while intoxicated and operating a vehicle, and that imposed, before that, the approximate cause of a collision with a drunk driver who'd been overserved was viewed as being the voluntary consumption of the alcohol by the driver. Piccadilly's in 87 or 88, handed down by the Indiana Supreme Court, said no, the proximate cause was the actual serving to that individual. It didn't relieve the individual, him or herself, of liability in a crash, but it extended liability, dram shop liability is what it's called, to the owner that overserved the individual. And that can extend to someone who has a private party. If you're having a private party, or we had disclaimers on our wedding invitations that said, while we encourage everyone to have a good time, we would also encourage them to have alternate means of transportation. And that was,
of course, those I'll come back to that point after.
Okay, we're at the end of our first segment, and we'll be back in just a minute. Something of a game.